Acquired archive record. Tonight, we're stepping into a slow unfolding. Settle in. Let the outside world dissolve, and gently descend into tonight's world. Tonight's record moves carefully, year by year, through the public record of Jeffrey Epstein, early life, education, entry into finance, the building of wealth and access, the first law enforcement investigation in Florida, the 2008 guilty plea, the long civil years that followed, and the 2019 federal arrest and death. Along the way, we separate what is verified from what is alleged, and we name uncertainty as uncertainty. This is not told for shock. It is a quiet documentary walk through dates, property records, court filings, and institutional decisions, with non-graphic language and no invented quotes. When allegations appear, we use careful phrases like was accused, was charged, pleaded guilty, and was convicted. This is Epstein, year by year. Jacques Chapter 1. Brooklyn Quiet. 1953 to 1976, 1953. The archive opens with one verified pin. Jeffrey Edward Epstein was born in 1953 in Brooklyn, New York. It is a small sentence, but it matters. When later stories become loud, the record still begins with ordinary facts. A birth year, a borough, a name. In a documentary file, that is the first anchor. 1954 to 1965. The public record is thin here, and we do not try to thicken it. These years do not sit inside court dockets or property databases. They are the kind of years most of us have. School days, family routines, the quiet formation of habits that never become searchable. The archive rule is simple. When the record is quiet, we leave it quiet. 1966. As adolescence begins, later biographies and press profiles often describe Epstein as academically strong, especially in mathematics. That is not a sworn statement. It is a recurring claim in public reporting. In an archive voice, we keep it in its proper place. Reported, not proven. 1967. A first institutional detail appears consistently in public accounts. Lafayette High School in Brooklyn. A school name matters because it anchors a person to a place. It reminds us the story began far from private jets and gated compounds. 1968. The late 1960s are a time of national turbulence. But the archive does not treat national mood as biography. We can say only that Epstein is a teenager in New York City, 1969. In 1969, he is still in the ordinary lane of life. The public record offers no event that deserves narration beyond the year marker, so we mark it and move. 1970. Public reporting has long stated that Epstein attended Cooper Union in New York City around this time. Some accounts also say he attended New York University. The most consistent public narrative is that he did not complete a degree. In the archive, this is not a moral judgment. It matters only because it contrasts with what comes next. A rise into elite spaces, where formal credentials are often a gate. 1971. The early 1970s remain thin. The archive does not have a clean, primary record of enrollment dates, transcripts, or degrees, and we do not pretend to. We simply note that the public narrative places him in New York and adjacent to education environments. 1972. A year of movement rather than documentation. When later stories claim to know exactly how a person felt in a year like this, the archive steps back. We only keep what can be kept. The shape of the path, not imagined interior scenes. 1973. This is a transition year in most public summaries, between youth and professional life. The archive voice names the thinness again, because honesty about gaps is part of the contract. 1974. A clearer entry appears. The Dalton School, an elite private school in Manhattan. Epstein worked there in the mid-1970s. The fact of the job is the key point, because Dalton is more than a workplace. It is a social gate, a place where wealth, family networks, and ambition overlap. In the year-by-year record, this is an early example of proximity, not to celebrity, but to families with resources and influence. 1975. Multiple sources report that Epstein taught mathematics and physics at Dalton. Some accounts also report that he was hired without a completed college degree. The archive cannot verify the internal rationale for a hiring decision made decades ago, so we do not argue with it. We only note why the detail matters. It suggests an early pattern where Epstein moved past formal filters. A prestigious job is not evidence of later crimes, but it is evidence of early access. 1976. By 1976, Epstein leaves Dalton. Public accounts differ on why. Some describe professional disputes. Some mention complaints. Without primary documentation, the archive does not declare a cause. What is verifiable is the pivot. He moves from education toward finance. This is the first major turn in the chronology. The environment changes from classrooms to markets, from lesson plans to transactions, from public institutions to private confidentiality. Thavre Chapter 2, Learning the Language of Wealth, 1977 to 1991, 1977. Epstein enters Bear Stearns, a major Wall Street firm, according to widely repeated public reporting. The archive does not romanticize Wall Street, but it marks the change. A financial firm trains people to speak in numbers, to move quickly, to handle pressure, to manage impressions. In elite finance, being trusted is an asset. This year also introduces a structural feature that matters later: confidentiality. In finance, discretion is not suspicious. It is expected. When private information is currency, the person who keeps secrets becomes valuable. In a documentary record, this matters, because later questions about Epstein often include questions about secrecy itself. How a person can build a life that is visible on the surface and opaque inside. A Wall Street beginning also matters for another reason. It teaches a person how institutions respond to risk, how compliance works, how reputations are managed, and how problems can be treated as liabilities to contain rather than harms to confront. 1978. Reporting describes Epstein working in areas involving options and similar instruments. Options are legal contracts, abstractions built on probability and timing. The archive does not turn that into metaphor, but it notes what the work teaches: how to price risk, how to make promises with fine print, how to speak confidently about uncertain outcomes. It also teaches the social etiquette of wealth, how to sound calm when money is moving quickly. A person who can do that becomes useful to people who want calm, especially when their money is not calm. 1979. Public accounts suggest Epstein advanced at Bear Stearns and worked with clients. The year-by-year point is exposure. It is not just a job. It is contact with people whose lives are structured around wealth, how they protect privacy, how they rely on intermediaries, how they delegate risk. In a quiet documentary voice, we observe that wealth creates ecosystems. Advisors, brokers, lawyers, accountants, assistants, drivers. A person who becomes useful inside that ecosystem gains leverage that is hard to measure from the outside. The archive also notes a subtle cultural lesson common in finance. Information is power, and power is not shared freely. 1980. By 1980, Epstein is reported to be established inside the firm. The archive does not have a single definitive public document that lists every promotion, but multiple independent press accounts over many years describe him rising quickly. We treat that pattern as a consistent public narrative, not as a sworn corporate history. What matters for chronology is that he is learning how money buys privacy and how privacy buys freedom. It is also the year-by-year period when Epstein, like many people in finance, would learn the language of legitimacy, the vocabulary of funds, trusts, foundations, and the polite phrasing that can make any transaction sound routine. 1981. Some reporting has said Epstein became a limited partner at Bear Stearns. Whether the exact title is verifiable in public records is less important than the stable point. He is perceived as successful and increasingly trusted. In documentary terms, perceived success becomes a passport. People make assumptions, and those assumptions open doors. The archive points out a quiet detail that will matter later. When a person appears to succeed inside a respected institution, outsiders often assume the institution has vetted them. That assumption can follow a person for years. 1982. Epstein leaves Bear Stearns. Public explanations vary. Some accounts suggest he was pushed out. Others suggest disagreement or internal conflict. The archive does not choose a motive. It marks the departure because it sets up the next phase. A private advisor without a large, visible firm behind him. This is the moment when the story begins to rely less on corporate records and more on private arrangements. Private arrangements can be lawful. They can also be difficult to investigate. A documentary timeline does not accuse. It notes the investigative reality. 1983. Epstein begins presenting himself as an independent financial advisor, often under the name J. Epstein & Co., in public reporting. That entity is frequently described as having very few clients. A small client list can be a sign of exclusivity. It can also be a way to keep the paper trail narrow. The archive does not accuse. It notes how the structure functions. If a firm has few clients, each relationship can be intensely private, and outsiders have fewer points of entry. In later controversies, this point becomes significant. There was long public confusion about how Epstein made his money. The structure of a boutique advisor with few clients is one explanation for why the public could not easily see the machinery. 1984. The outline of his life becomes harder to trace, not because nothing happens, but because private advising is designed to be private. What the record does show, in scattered press mentions and later investigative reporting, is a growing presence in wealthy social circles. This year is less about a single event and more about the consolidation of an identity, not employee, but gatekeeper. In the archive voice, we also highlight a common misreading. People sometimes assume that if wealth is hard to explain, it must be illegal. The archive cannot make that claim. It can only say this: the mechanisms of his wealth were not transparent to the public, and that lack of transparency later fueled suspicion. 1985. A reported relationship becomes central. Les Wexner, an influential businessman. Public reporting has described Epstein as a financial advisor and close associate of Wexner in this period. The full internal details of their relationship are not available in a single public, authoritative dossier, but the year-by-year significance is clear. Association with a prominent figure functions like certification. In elite environments, a patron can replace a resume. The archive also notes the way a relationship like this changes a person's perceived category. Before, Epstein is a young man from Brooklyn who worked at a Wall Street firm. After, he is seen as someone trusted by a powerful figure. Trust in elite society is often contagious. 1986. Epstein's social visibility increases. Some of this is documented through press profiles, later reporting, and property-related discussions. The archive remains careful. Visibility does not prove wrongdoing. It proves access. And access can be neutral, but access can also be used. This is also the year-by-year period when Epstein begins to be described not just as a money person, but as a person who can connect money to ideas. That description will matter later when we see his presence around science and philanthropy. 1987. The record in 1987 is mostly environmental. Epstein is described as moving among wealthy donors, finance contacts, and social figures. The story is not yet a criminal docket. It is a network. The archive notes a simple truth. Networks can protect people. Networks can also expose people. Which one happens depends on what institutions choose to see and what they choose to ignore. The archive also notes a quieter truth. A person who moves between networks can carry information from one to another. That can make them valuable. It can also make people fear crossing them. 1988. The late 1980s show repeated patterns in public accounts. Dinners, introductions, travel, private meetings. These are ordinary actions in high society. But in the archive frame, they are also infrastructure. A person who hosts becomes a center of gravity. A center of gravity becomes difficult to question, because questioning can threaten access. Again, we do not claim wrongdoing. We name the social mechanics. 1989. A specific piece of real estate becomes relevant in later reporting. A large townhouse on East 71st Street in Manhattan, purchased by Wexner in 1989, according to widely reported accounts. The archive is careful. Purchase records can be verified. The meaning people assign to them often cannot. But the house matters, because later Epstein is associated with that address, and the property becomes part of the public question. How did he acquire such a platform, and what did it allow? A townhouse of that scale is also a practical fact. It allows hosting. It allows staff. It allows a private world within the city. In later years, that private world becomes relevant in allegations and in public scrutiny. 1990. Palm Beach enters the timeline as a location that will later become central. Property records and public reporting have described Epstein purchasing a mansion in Palm Beach around this period. A residence like that is more than square footage. It is staff. It is controlled access. It is private space inside a public resort culture. This year is also where we have to introduce a difficult boundary. Multiple women later alleged that Epstein sexually abused and exploited them across the 1990s and early 2000s, including when they were minors. Those are allegations. Many were not tested in a criminal trial at the time, but they are part of the historical record because they shape the later legal response and the later public understanding. 1991. By 1991, Epstein is widely described as wealthy and connected, even as the precise sources of his wealth are not transparent to the public. The archive does not treat opacity as proof of illegality. It treats opacity as a condition that makes accountability harder. When money is private and relationships are private, the public learns details slowly, often only after harm is alleged. This year also closes Chapter 2 with a reminder. Before the law ever enters the story, the environment is being built. Properties, staff, social proof, and a reputation strong enough that many people will hesitate to challenge it. Ksharadam, Chapter 3, Residences, Networks and Warnings, 1992 to 2002, 1992. The early 1990s show a widening footprint. Public reporting describes Epstein maintaining a Manhattan residence and a Palm Beach residence with staff and controlled access. In year-by-year documentary language, residences are not just homes. They are controlled environments. They allow a host to set rules, decide who enters, decide who is isolated, and decide what outsiders do not see. When later allegations describe harm taking place in private spaces, the existence of those controlled spaces becomes part of the chronology. The archive also notes an institutional reality. Private homes are not regulated like public venues. When harm is alleged behind closed doors, the path to proof is harder. 1993. Reporting and later investigative work describe additional property interests becoming part of Epstein's life over the decade, including a ranch property in New Mexico mentioned repeatedly in later civil and criminal records. The archive avoids locking in a purchase date if it cannot be verified in one clean public record. The safe point is that by the mid-1990s, the ranch is a recurring location in allegations and travel narratives. This year also illustrates a theme. The story expands geographically. Distance can dilute oversight. A person can move between jurisdictions, between social circles, between legal cultures. In the archive, geography matters because law is local. Police departments are local. Prosecutors are local. A person with multiple homes can also have multiple versions of themselves. 1994. Epstein becomes more visible in social and philanthropic contexts. Some donations are documented in institutional acknowledgements and later reporting. The archive keeps a clear distinction. Philanthropy can be real and beneficial, and it can also function as reputation management. Those statements can both be true. When a donor funds an institution, the institution receives resources. The donor also receives legitimacy. In later years, legitimacy can operate like armor. This year also hints at a pattern that becomes stronger in the late 1990s. Epstein is increasingly described not only as a financier, but as a patron of ideas. That description will be repeated in profiles and introductions. 1995. Retrospective accounts sometimes describe rumors and warnings circulating in certain social circles. Hindsight is both powerful and unreliable. People remember what later becomes meaningful. So the archive does not treat retrospective warnings as definitive proof that specific individuals knew specific facts in 1995. It treats them as evidence that discomfort may have existed earlier than the public knew. This year is also important for another reason. It illustrates how a private life can be invisible even while a social life is visible. A person can be photographed at dinners and still be unknown in the ways that matter. The archive notes that this invisibility is not magic. It is routine. It is the routine privacy that wealth buys. 1996. A major property detail becomes part of the public narrative. The Manhattan townhouse, purchased by Wexner in 1989, is later reported to have been transferred to Epstein in 1996, in accounts that drew intense scrutiny. The archive does not litigate motives. It marks the transfer as a publicly reported milestone because it deepens a question about power, how wealth and trust can be gifted, and how that gift can change what a person can do. This year is also a reminder that property records are one of the few durable traces in a life otherwise built around privacy. In a case defined by secrecy, durable traces become the spine of later reporting. 1997. Ghislaine Maxwell appears repeatedly in public reporting as a close associate of Epstein during the 1990s. At the time, she is documented largely as a social figure. Much later, federal prosecutors alleged she played a role in recruiting and grooming underage girls for Epstein. She denied wrongdoing. She was convicted in 2021. That conviction is a matter of record, but it is important not to collapse the whole timeline into the later trial narrative. In 1997, we mark presence and association as reported, without importing conclusions beyond what is established in court. This year also introduces another documentary principle. When a person is later convicted, observers often try to rewrite earlier years, as if the conviction was already known. The archive does not do that. It keeps time moving forward, not backward. 1998. A purchase can be supported through records and repeated reporting. Epstein bought Little St. James in the US Virgin Islands in 1998. The island will later become a symbol. The archive resists symbol making. It holds the purchase as a fact and notes how places acquire meaning when allegations attach to them. A private island is also a practical fact. It is distance. It is controlled access. It is jurisdictional complexity. When later allegations involve movement of people across locations, the existence of a private island changes the logistical story. It creates a place where the host controls the approach, the schedule, and the visibility. 1999. As the millennium approaches, Epstein is described as hosting dinners and cultivating relationships in academia, philanthropy, and politics. The archive treats gatherings as strategy without sensationalism. Hosting is a form of power. It allows a person to curate who meets whom and to create obligations that are social rather than contractual. At the same time, we repeat a key documentary caution. A guest list does not prove criminal conduct. It proves proximity, and proximity can be innocent. But proximity can also be part of how people later defend themselves by claiming they were only near the story, never inside it. The archive also notes how an elite network can create a kind of distributed alibi. If everyone is connected loosely, no one feels responsible. If everyone knows a little, no one says they knew enough. 2000. Palm Beach becomes more central in the later investigative record. The town is a place of wealth, but also a place with a smaller social geography. People notice patterns. Staff talk to staff. Teenagers travel in familiar loops. The archive does not invent scenes. It simply notes why, in later investigative files, Palm Beach matters. It is where complaints were made and where early law enforcement work built a case. This year is also where the broader public narrative begins to fracture. To some observers, Epstein is a financier and a donor. To others, he is a man whose private life is whispered about. The archive does not validate whispers. It notes that whispers often precede documentation. 2001. After September 2001, national attention shifts. Many institutions focus on security and crisis response. The archive does not claim that public distraction causes private harm. It notes a practical reality. Stories compete for attention, and some cases do not get the spotlight they might otherwise receive. Victims later alleged abusive conduct continued through these years. These are allegations, but their repetition across accounts is part of why the story returned to public view. This year also reminds us of a harsh truth. Harm can continue in plain sight when the people around it do not know what they are seeing, or when they do not want to see it. 2002. By 2002, Epstein's name appears more clearly in connection with donations, foundations, and elite institutions, according to public reporting and later institutional reviews. The archive treats this as an important precondition for what happens later. When a person is linked to respected institutions, scrutiny becomes harder. People hesitate, they rationalize, they assume someone else checked. Chapter 3 ends with quiet tension. The surface record is wealth and access. The under record is a growing set of allegations and warnings, still not fully addressed by the criminal justice system. Jiaru, Chapter 4, Investigation, Negotiation, and a Plea, 2003 to 2008, 2003. In Palm Beach, law enforcement attention begins to cohere. Public reporting and later documents describe complaints, interviews, and the early assembly of an investigation involving multiple alleged victims. In the archive voice, we avoid graphic detail. We focus on process. Who receives a report? Who writes it down? Who decides whether it is credible? And what happens when credibility meets power? A year like 2003 is also about first reactions. Does a system treat a report as a nuisance or as a warning? Does it see a pattern or only isolated statements? The archive cannot restage the initial conversations. It can only note that by the end of 2003, the story has moved from rumor to investigation. In later public accounts, 2003 is often remembered as the year when the first documented complaints start a chain reaction. That chain reaction will travel through police files, prosecutor decisions, and eventually national headlines. 2004. The Palm Beach Police Department continues investigating. In year-by-year terms, 2004 is about accumulation. More interviews, more statements, a clearer picture inside the investigative file. A quiet archive voice notes how investigations are built from ordinary tools. A calendar entry, a phone call, a written statement signed at the bottom. These are not cinematic objects. They are the mechanisms of accountability. This is also the year when a key tension begins to form. Local investigators may build a case with one vision of seriousness. Prosecutors may view the same facts through a different lens. What can be proven beyond a reasonable doubt? How sympathetic a jury might be? What resources the office will spend? The archive does not take sides. It notes that legal seriousness and moral seriousness do not always line up. This year is also where the archive begins to notice time pressure. As the months pass, witnesses age, families move, memories blur. A case that feels urgent in a detective's notebook can become less urgent in an office calendar. Time can be a kind of defense. 2005. The investigation gains momentum. Public accounts describe the case being presented to prosecutors and the possibility of serious charges becoming more real. This is also a year when many later summaries place an important escalation. The number of alleged victims becomes a central fact in discussion of the case. Even when individual allegations are not tested in criminal court, the existence of multiple similar allegations affects how a case is understood. The archive keeps language careful. These were allegations, but the fact that law enforcement recorded them and treated them as part of an investigation is part of the public timeline. The archive also notes a procedural reality. When a case involves multiple alleged victims, prosecutors face choices. Do they build a broad case that takes longer and risks complexity? Or do they narrow the case to something easier to prove quickly? Those choices shape outcomes. 2006. The path to charges becomes complicated. Public reporting describes a process involving both state and federal considerations. There is also public reporting about a state grand jury in Florida and an outcome that many observers later described as far less severe than what local investigators expected. The archive treats the grand jury process carefully. Grand juries are secret by design. They produce indictments, not full public explanations, so we avoid claiming to know what was argued in the room. We can only say this: the public outcome, as widely reported, did not end the case. Instead, it pushed the story into negotiation. In the archive, 2006 is the year when the distance between investigation and prosecution becomes visible. An investigator can feel sure. A prosecutor can feel cautious. A defendant with resources can expand that caution with legal pressure. Again, this is not an accusation about one person or office. It is an institutional reality. It is also the year when the word jurisdiction becomes more than a map. Different offices have different authority. A case can move from local to federal and back. As it moves, decisions can be revisited and reshaped. 2007, negotiations intensify. This is the period associated with a non-prosecution agreement that later became one of the most criticized documents in the Epstein chronology. In broad, responsible language, the public record reflects this. Federal prosecutors negotiated an arrangement under which Epstein would plead guilty to state charges, and federal prosecutors would decline to pursue certain federal charges. A notable feature of this agreement, as discussed widely in later reporting and litigation, was its secrecy. Another notable feature, as discussed in public sources, was language that affected potential co-conspirators. The archive does not editorialize. It notes the consequences of secrecy. When agreements are quiet, accountability becomes harder. People outside the room cannot evaluate the reasoning, the trade-offs, or the pressure. A central controversy involves victim notification. Victims later argued they were not properly informed and that their rights under the Crime Victims' Rights Act were violated. This argument became the basis for long litigation. In year-by-year chronology, 2007 is the year when the legal system makes a decision that will be questioned for more than a decade. It is also the year when many observers later said they saw a pattern, a negotiation process that, in their view, prioritized a contained outcome over a full public trial. The archive cannot adjudicate intention. It can only show effect. The effect was a plea structure that closed one door while leaving many questions open. The archive also marks a secondary effect that became clear only later. Because the agreement was negotiated and kept quiet in key ways, it shaped what the public believed the case was about. A narrow public outcome can narrow public imagination. If the official story is framed as solicitation, the public may not immediately understand the scale of the allegations described by multiple victims. That gap between the official charge language and the allegations described in police files and later civil filings became one of the reasons the story returned. In year-by-year terms, 2007 is also a lesson about leverage. A defendant with extensive resources can retain experienced counsel. Counsel can negotiate hard. Counsel can raise uncertainty. Counsel can emphasize the risks of trial. None of that is illegal. It is the system operating. But the archive notes the unequal distribution of those tools. Most defendants do not have them. When an agreement is negotiated under that imbalance, the outcome can look less like a pure evaluation of evidence and more like a negotiated containment of risk. Again, the archive does not claim what any individual intended. It notes the structure, serious allegations, a complex investigation, and a resolution that many later viewed as unusually favorable. Another part of the 2007 record, as described in later reporting and litigation, is how victims experience the process. In criminal law, victims are not prosecutors, and they are not parties in the same way. But they are people with legal rights and human stakes. When victims later said they were not adequately informed while negotiations were occurring, the story became not only about Epstein, it became about the system that negotiated on their behalf. The Crime Victims' Rights Act, invoked later in litigation, is one reason 2007 remains central. It created a framework for arguing that secrecy was not only unfair, but unlawful. The archive does not present the litigation as a simple morality play. These cases are complex. They move slowly. They turn on procedure and interpretation. But the year-by-year consequence is clear. Because of what happened in 2007, survivors and advocates spent years in court trying to reopen a closed chapter. That persistence becomes a bridge to the renewed attention of 2018 and the federal arrest in 2019. 2008. A major legal fact arrives. Epstein pleaded guilty in Florida state court to charges that included solicitation of prostitution and solicitation of prostitution from a minor. He was convicted on those charges. He was sentenced to incarceration and required to register as a sex offender. Public reporting described his confinement as involving a work release arrangement that allowed him to leave jail for many hours each day. This arrangement was widely criticized. It became a symbol for many observers of unequal justice, though the archive uses the term symbol carefully. Here, the archive makes an essential distinction. The plea and conviction are facts. The broader allegations described by victims extend beyond the specific charges resolved in the plea. Many people believed, and many victims stated, that the legal outcome did not reflect the full scope of alleged harm. The archive also notes another structural fact. A plea resolves a criminal case, but it does not erase what happened. It does not erase the statements taken in interviews. It does not erase the memories of those who say they were harmed. It often does not produce a full public accounting. In a documentary timeline, 2008 is the year when accountability takes a formal shape, but leaves a wide shadow. The archive names what that formal shape included, because details matter. A guilty plea is entered in court. A judgment of conviction is recorded. A sentence is imposed. Registration requirements follow. Conditions of supervision follow. Those pieces are the official record. But the archive also notes why 2008 became a lasting controversy. First, the plea was limited compared with the scope of allegations described by multiple victims. Second, the work release arrangement, as reported publicly, created a perception that punishment was porous. A person could be convicted and still spend much of each day outside the jail. To many observers, that looked like a separate system. To many survivors, it felt like a message. The archive cannot speak for every survivor, but it can say that public reporting and later commentary repeatedly returned to this arrangement as evidence of unequal consequence. Third, the use of plea bargaining itself is ordinary in criminal law. Most cases end in pleas. But this case became famous because the plea was paired with a broader agreement that affected federal prosecution. That combination made 2008 feel, to many, like a closing of doors rather than an opening of truth. The archive also notes a fourth factor. A plea ends a case quickly. Quick endings can be useful. They can spare victims from trial. They can conserve resources. They can reduce uncertainty. But quick endings also reduce discovery. They reduce the number of witnesses who testify in open court. They reduce the number of documents that become exhibits. They reduce the public's ability to understand what happened. That reduced understanding became part of the long after. The record also shows something else. Once a plea is entered, the system often moves on, but survivors do not. Chapter 4 ends without triumph. It ends with an administrative closure that did not feel like closure to many survivors. Chapter 5. Civil Years and Returning Light. 2009 to 2016. 2009. The post-plea timeline begins with a shift. Epstein is now a convicted sex offender, and he is also a man with wealth, lawyers, and social connections. Public reporting describes his release from incarceration and the beginning of a period defined by civil litigation, media scrutiny, and continuing public argument about what 2008 did and did not resolve. This year is also the beginning of a long afterlife for the Florida deal. Because the agreement existed, and because it was widely viewed as unusually favorable, it became a reference point. Not just for this story, but for broader questions about power and prosecution. Victims pursued civil claims. Some cases resulted in settlements. Settlements are part of the record, but they often come with confidentiality and without admissions. The archive pauses to name what civil litigation can be: a fight for documents, a fight for acknowledgement, and often a fight simply to be taken seriously. The archive also notes something that happens after a plea. Public attention may fade, but survivors continue living with the consequences. The civil years become, for many, the only available path to any form of accountability. And in 2009, another theme emerges. The story begins to split into two tracks. One track is formal: court filings, motions, settlements. The other track is social: who still meets with him, who still takes his calls, who still accepts his hospitality. A documentary record has to track both, because in this case, social acceptance is part of how influence persisted. 2010. Public reporting describes Epstein continuing to travel and to maintain relationships despite his registered status. The archive does not claim that everyone who interacted with him knew every allegation. Knowledge is uneven, but the year-by-year fact is that social access persisted. Elite environments did not uniformly close. This year also reflects a practical truth about consequence. A conviction imposes formal restrictions, but informal restrictions are social. They depend on what people decide to tolerate and on what institutions decide to forget. In 2010, the archive sees a kind of normalization. Some people treat the conviction as a closed chapter. Others treat it as a warning. Those two interpretations coexist, and that coexistence helps explain why the story did not end. The archive also notes the shape of post-conviction life for a wealthy defendant. Many people imagine a convicted sex offender as isolated. In this story, public reporting describes something different: continued movement, continued contact, continued power. The contrast becomes part of the moral weight of the archive. 2011. Allegations continue to surface through civil filings and public reporting. Epstein denied wrongdoing beyond what he pleaded to in Florida. Disputes continued in court. In year-by-year terms, 2011 is not a single headline. It is a year of ongoing pressure. A pressure that does not resolve into a criminal verdict, but does accumulate. The archive maintains discipline. We do not turn allegations into a catalogue designed to overwhelm. We observe patterns as patterns, and we keep language careful. Alleged, accused, claimed. We also note that civil cases have a different purpose than criminal cases. Civil litigation can seek damages, documents, accountability, and leverage. It does not require a prosecutor. It can proceed even when the state chooses not to act. That difference becomes important in this story. This year also highlights an often missed feature of civil litigation. It can force a conversation about truth even without a verdict. Depositions can be taken. Documents can be demanded. People can be placed under oath. But the public may never see much of it. The archive notes that tension. A case can be legally active and socially invisible at the same time. 2012. Documents circulate more widely in public discussion. People talk about flight logs, contact books, and deposition excerpts. The archive offers a warning that is easy to forget. Documents can show proximity without proving criminal participation. A name in a book can mean a business contact, a social contact, or something else entirely. A travel record can show that two people were on the same plane. It does not, by itself, prove what happened in a private room. Still, these materials matter. They map the ecosystem around Epstein, the routes, the circles, and the scale. The archive also notes a deeper reason these documents become so important. When a criminal case ends in a plea with limited public disclosure, people search for other ways to understand the story. They use what they can find. Sometimes they use it responsibly. Sometimes they do not. This year also shows a human reality. Survivors and advocates often become record keepers. They learn legal language. They learn filing systems. They learn how to keep their own archive because the official archive can feel incomplete. 2013. Media coverage continues. Epstein is described in connection with powerful and famous individuals. Some people issue statements distancing themselves. Others remain silent. Silence is not a legal admission. Statements are not a full account. The archive does not punish people for not speaking, and it does not exonerate people for speaking. It simply notes how reputation management becomes part of the story. A documentary record is not just about crimes. It is about institutions, and the institution here includes the public. How quickly do we move on? What do we tolerate? What do we demand proof for? And what do we assume? In 2013, the archive also sees the effect of time. As years pass, documents are harder to find. Memories are challenged. Statutes of limitation become issues. Time can protect a defendant. Time can also burden a survivor. But time can also bring a different kind of evidence. Patterns become clearer. Multiple accounts can be compared. People who were afraid to speak can find strength. The archive notes that time is not only erosion, sometimes it is accumulation. 2014. Civil litigation and investigative reporting keep pressure on the narrative. The name Virginia Giuffre becomes prominent in public coverage. She alleged that she was recruited, trafficked, and abused when she was a minor. Epstein denied her allegations. The archive repeats the key legal boundary. A civil allegation, even a detailed one, is not the same as a criminal conviction. But the existence of consistent allegations across multiple people is historically significant. It changes how the 2008 plea is interpreted. It changes how people view the question of whether justice was done. It also changes the future. Because when allegations do not go away, institutions eventually face a choice: ignore, settle, or investigate. The archive also notes a documentary problem. Public conversation can become simplified. People want a single narrative, a single villain, a single explanation. But the record is multi-layered. It includes alleged acts. It includes proven convictions. It includes decisions by prosecutors. It includes actions by institutions that accepted money. It includes social choices by people who remained close. The year-by-year format is one way to resist simplification. 2015, a documented milestone. Epstein and Jeffrey reached a settlement. A settlement is not an admission of guilt. It is a legal resolution that often leaves the factual dispute formally unresolved. This year also deepens a broader theme: transparency. Observers sought access to sealed records, and debates about unsealing became part of the public process. People wanted to know who knew what and when. The archive treats the desire for a list with caution. The story is not only about a list, it is about systems, but the desire for names is understandable. People look for accountability in a world where accountability often feels delayed. In the record, 2015 is also a year when Epstein's name continues to appear in contexts that surprised many observers. The surprise is itself instructive. It shows how quickly elite environments can absorb a scandal, reframe it as a resolved matter, and move forward. 2016, cultural context shifts. The broader society becomes more willing to confront stories of sexual abuse and power. That does not automatically create justice, but it changes incentives. The archive notes, quietly, that reputational risk is not the same as moral responsibility. But institutions often move faster when they fear public consequences. In year-by-year terms, 2016 is a year when the story is ready to return. The allegations are not new. The questions about the plea deal are not new. What is changing is the climate. The archive also notes a quieter trend. In many abuse cases, society cycles through attention and forgetting. 2016 sits at the edge of a new cycle, a cycle where survivors are more likely to be believed, where institutions are less confident they can keep matters sealed, where journalists have a larger audience for long investigations. Chapter 5 ends with a waiting feeling. The story is not finished. It is waiting for another investigation, another indictment, another moment when the legal system returns. Narration, Chapter 6. Federal charges, death, and the long after. 2017 to 2019 and beyond 2017. Old decisions are revisited. Victims and advocates continue pressing for accountability, including litigation connected to victim rights arguments about the earlier federal non-prosecution agreement. In the archive, 2017 is important because it shows persistence. A system may treat a case as closed. Survivors may not. When survivors return to the record year after year, they create a second timeline, a timeline of insistence. This is also a year when media and public attention periodically reflares. The story never fully disappears. It returns in waves, often tied to court filings, unsealed documents, or renewed reporting. The archive notes that this persistence is part of what eventually changed the case. A closed file can be reopened when pressure does not stop. 2018. A major journalistic event becomes a turning point. The Miami Herald published a widely cited investigative series examining the Florida plea deal and describing the experiences of victims. Journalism is not a courtroom verdict, but it can be part of the archive. It can quote documents. It can name timelines. It can connect decisions that were previously separated. In 2018, the file begins to tighten. A story many believed ended in 2008 begins to re-enter criminal attention. The archive notes why a renewed look is not simple. When prosecutors revisit an old case, they inherit the consequences of earlier choices. Evidence has aged. Witnesses have built new lives. Some records are gone. And yet, an old decision can still be questioned if new reporting reveals facts the public never saw. In 2018, that is part of what happens. The public learns more about how the 2008 outcome was constructed, and the demand for review grows louder. The archive notes a practical effect. When a case is public, institutions feel watched. When institutions feel watched, they sometimes act. This year also demonstrates a reality about accountability. Sometimes it arrives through the legal system. Sometimes it arrives through the press. Sometimes it arrives because survivors keep telling their story until someone with authority finally listens. 2019. The federal criminal case arrives. In July 2019, federal prosecutors in the Southern District of New York arrested Epstein. He was charged with federal offenses related to sex trafficking and conspiracy. The indictment alleged that he exploited and abused minors and young women over many years. Epstein pleaded not guilty. Bail was contested. The case drew intense attention because it appeared to reopen a chapter many believed had been sealed. In year-by-year terms, 2019 is also about the collision between the earlier plea deal and the new federal charges. To many observers, the new case looked like a correction. To others, it looked like too late. Public reporting described searches of properties and the seizure of evidence. The archive holds these as reported actions by law enforcement, part of a case that was finally moving toward trial. The year-by-year record also includes the procedural steps that often get blurred in retelling. A federal arrest is followed by an initial court appearance. Charges are read. Lawyers argue about detention. Prosecutors describe risk. Defense counsel proposes conditions. A judge decides. In 2019, bail was contested and the court proceedings became part of the public story. The archive does not dramatize those hearings, but it notes why they mattered. A detention decision is not only about one defendant, it is also about the court's judgment of risk of flight, risk to the community, and the practical ability of a person with resources to evade supervision. When a defendant has wealth, a private plane, and international ties, the question of flight is not abstract. It becomes a central argument. Public reporting also described how prosecutors framed the alleged conduct. They described a long-running scheme. They described recruitment. They described payments. They described minors. Those were allegations in an indictment. But the fact that federal prosecutors were willing to frame the case that way in 2019 is part of the historical record. It shows a shift from the narrow public frame of 2008 to a broader federal accusation. The archive also marks the evidence problem created by time. The alleged conduct described in the indictment spanned many years. By 2019, some witnesses had moved, changed names, or avoided the public. Some memories had aged, some records were incomplete. The case was moving toward trial, but it was moving through decades. This is one reason the 2019 arrest carried such weight. It looked like a late attempt to put the full story into a courtroom. It also looked to many survivors like one last chance. In custody, Epstein was held in a federal detention facility. Public reporting described restrictive conditions and heightened scrutiny. After his death, there were official investigations and internal reviews described publicly, focused on procedures, staffing, and supervision. The archive does not turn that into speculation. It simply notes that 2019 did not end only with a death. It ended with questions about institutions, a jail, a chain of decisions, and a system that again failed to deliver a trial. In August 2019, Epstein was found dead in his jail cell. The official ruling was suicide. His death ended the federal criminal case against him because a criminal prosecution cannot proceed against a deceased defendant. The archive pauses here because many people seek a clean ending. Archives rarely offer clean endings. They offer administrative closures and human questions. There were investigations and reviews after his death. There were public arguments about how such a death could occur in federal custody. The archive does not resolve those arguments. It marks the verified fact. He died in custody, and the case against him ended without trial. After 2019, the timeline does not stop. In the public imagination, 2019 can feel like an ending because the defendant died. In the archive, it is a hinge. A criminal case ended, but civil claims continued, institutional reviews continued, and a related prosecution continued. The year-by-year record after 2019 is not about one man anymore. It is about systems, estates, courts, victims, co-defendants, and the long work of figuring out what happened when a trial never occurred. 2020, civil litigation continued against Epstein's estate. An estate case is a different kind of accountability. It can produce compensation, it can produce documents, and it can produce public facts through filings. But it cannot produce a criminal verdict against the deceased. The archive notes the emotional complexity of this year. For many survivors, the federal arrest in 2019 created the possibility of testimony in open court. The death ended that possibility. In 2020, survivors are again asked to accept an administrative outcome. Public attention also shifts in waves. When a story does not have a trial, it must compete with other news for oxygen. And yet, 2020 also brings a major verified development. Ghislaine Maxwell was arrested in 2020 on federal charges. In public terms, this was presented as a continuation of the 2019 federal case, an attempt to hold someone accountable in court even after Epstein's death. The archive keeps the legal language careful. Maxwell was charged. A charge is an accusation, not a verdict. 2021. Maxwell went to trial in federal court in 2021. The case presented testimony and evidence focused on the period when prosecutors alleged she assisted Epstein in recruiting and grooming underage girls. The archive does not summarize testimony as fact. In a documentary timeline, we separate categories. Testimony is evidence presented under oath. A jury verdict is a legal finding. In 2021, the verified outcome is this: Maxwell was convicted by a jury on federal charges. The archive pauses on what that means. A conviction is not a headline. It is a legal finding. It means jurors heard evidence and concluded, beyond a reasonable doubt, that crimes were committed as charged. It also means that some of the narrative that had lived for years in allegations and civil filings was finally tested inside a courtroom. That testing matters even when the courtroom cannot answer every question. A criminal trial focuses on specific counts and specific elements. It does not try to explain a whole social ecosystem. It tries to prove narrow facts to a legal standard. In 2021, that narrow legal process produced a result that became part of the permanent record. The conviction also reframed public discussion. For years, Maxwell was described in reporting as an associate. After 2021, she was a convicted defendant. That change is not about language. It is about category. It changes how institutions speak. It changes what lawyers can argue. It changes what is treated as established. The archive also notes a sober limitation. Even a conviction does not automatically produce a complete map of the past. Trials have rules of evidence. They have limits on what can be introduced. They have witnesses who can be challenged. They have juries that decide only what they are asked to decide. So in a year-by-year documentary record, 2021 is not the year the whole story becomes known. It is the year a portion of the story becomes legally confirmed. The conviction becomes part of the public record, and it changes the historical timeline. It means a court has found, beyond a reasonable doubt, that Maxwell committed crimes connected to the trafficking scheme described by prosecutors. The archive also notes what the trial did and did not do. It did not put Epstein on trial. It did not produce a complete map of every person who interacted with him. But it did create a public record of witnesses, exhibits, and findings that did not exist in the same way in 2008. For the year-by-year story, 2021 is a year when some of the long-held allegations are addressed in a courtroom setting, even if the central defendant is absent. 2022. In 2022, Maxwell was sentenced. Sentencing is not only punishment, it is also a public statement of what a court believes has been proven. The archive treats sentencing as part of the record because it formalizes the conviction and its consequences. Meanwhile, the civil landscape continues. The archive notes a difference between criminal and civil accountability that becomes clearer in 2022. In a criminal case, the state prosecutes and a sentence is imposed. In a civil case, individuals seek damages, discovery, and negotiated outcomes. Civil cases can surface documents. They can reveal how institutions handled complaints. They can reveal what agreements were signed and when. But they also often end with private terms. That privacy can feel like another layer of silence to survivors and to the public. And yet, for some survivors, civil resolutions are the only resolutions they ever receive. So the archive refuses to treat civil outcomes as lesser. They are different. They operate under different standards. They require different kinds of courage. Claims against the estate and settlements that may follow are not the same as a verdict, but they are part of how survivors obtain recognition and resources. The archive remains careful with the word settlement. A settlement can happen for many reasons. It can reflect legal risk. It can reflect a desire to avoid publicity. It can reflect a desire to move on. It is not, by itself, a criminal finding. 2023. By 2023, the Epstein archive is also an archive of secondary questions. How did the 2008 deal happen? Who reviewed it? What did prosecutors believe they could prove? What was the role of institutional reputation? What did wealthy networks shield, and what did they expose? These questions appear in reporting, in memoir-like accounts, and in ongoing legal disputes. The archive does not convert questions into answers. It does not treat public suspicion as evidence. But it marks that 2023 is part of the long after. A year when the case is discussed as an example in broader debates about the justice system. It is also a year when survivors continue to live with the consequences of a delayed and incomplete legal process. 2024 and beyond. The story persists because archives persist. Documents remain. Court records remain. Property records remain. And the social record remains. Photographs, invitations, contact lists, and the traces of a network. The archive notes a calm truth. A timeline does not deliver justice. It delivers clarity. Clarity is not comfort. Clarity can be cold. It can show, in plain order, how long warnings sat without action. It can show how a person can be convicted in one jurisdiction and still be welcomed elsewhere. It can show how institutions can accept money, accept introductions, accept proximity, and still claim they never saw the harm. In the Epstein record, clarity also means resisting easy shortcuts. It means refusing to turn association into accusation. It means refusing to turn rumor into fact. It means stating, again and again, what is verified and what remains alleged. This discipline is not a stylistic choice. It is the only way an archive remains useful. Because a case like this generates noise. People want lists. People want villains. People want a single explanation. But the record is layered. It is made of decisions. It is made of incentives. It is made of silence. And it is made of survivors who insisted on being heard year after year. It shows when decisions were made and how long it took for consequences to arrive. It shows the difference between allegation and conviction. It shows how often institutions moved only when forced. The archive holds a final line of discipline. We do not add what we cannot prove. We do not sensationalize what is already tragic. We keep our words steady. Year by year, the record shows access and delay. Doors that stayed open, warnings that did not become action, and a legal response that arrived late and unevenly. We close the file gently. We leave the questions where they belong, in the public record, in the ongoing work of accountability, and in the lives of survivors who carried their truth across years of silence. This was a quiet archive story, where the story ends, sleep begins,